Domestic abuse as a topic is quite important, especially considering the current situation of our country, where we are tackling the COVID-19 virus alongside a serious increase of domestic abuse rates inside the country, possibly owing to the fact that the victims are now 24/7 confined into their homes alongside their perpetrators, and thus resulting in an increase in the rates of abuse. According to government statistics, only as little as 28% of victims actually seek help. And this number could be low owing to cultural reasons, owing to a fear of reprisals, owing to concerns regarding their children. But most importantly, this could be owing to a genuine lack of knowledge as to where to go for help. We have observed that around 3/4 of those who seek help have done so from family members or friends or neighbors or such personal contacts, and only as little as 18% have actually gone to institutions like the police for help. It's also important to be aware of what types of violence takes place. This can range all the way from verbal abuse to more serious offenses like rape. And from the reported types of violence, around 15% claim that they were forced into having sex, around 3% claim that they were burned, and around 13% claim that they were strangled. And it's important to note that most of these cases of abuse takes place daily. The laws that are prevalent in Sri Lanka with regard to domestic violence can be derived from the Prevention of Domestic Violence Act of 2005, and the Act itself also sets out a series of offences within the Penal Code, which will also apply. Chapter 16 of the Penal Code sets out a series of offences including rape, an attempt to commit murder or culpable homicide, causing hurt, which includes bodily pain, disease or infirmity, causing wrongful restraint or confinement, causing criminal force and assault, kidnapping, abduction, slavery, causing miscarriage or causing injury to unborn children, causing unnatural offenses, which are offenses considered to not be within the natural order of things. These all, under Chapter 16, falls within acts that would amount to domestic violence. And further, in Section 372 of the Penal Code, you have the offense of extortion, which is inducing fear in the victim in return for something valuable from them. Section 433 also sets out the act of criminal intimidation under the Penal Code. So all of these offences, as well as any attempt to commit those offences, would give rise to a charge against domestic violence. Apart from all of that, the 2005 Act also makes way for emotional abuse, which is basically any inhuman treatment or humiliating conduct directed towards the victim would amount to emotional abuse, under which you can bring a charge. Further, there is a bit of a grey area as to who can commit domestic violence. There is a common misconception that it has to be an intimate partner or a spouse that commits domestic violence against you. But the law provides for more than that. The spouse can commit, the former spouse can commit, a cohabitee can commit violence against you, but also, according to the law, your parents, grandparents, step-parents, children, grandchildren, stepchildren, siblings, half-siblings, step-siblings, aunts, uncles, nephews and nieces and such relatives are also capable of committing domestic violence against you. And this doesn't have to be necessarily your relatives, but also the relatives of your spouse, of your former spouse, or of your cohabitee are also capable of committing these offences against you. And if you happen to be a victim of domestic abuse, it's necessary that you stay aware of the legal proceedings that you can initiate. You can make an application in the magistrate's court, either directly, or you can have a police officer make that application for you at the magistrate's court. And the court, if it sees fit, before giving out a protection order, it will grant what is known as an interim protection order, which is meant for your immediate safety and to sort of protect you from any immediate danger of violence in the hands of your perpetrator. And in the meantime, the court can appoint any official or a counsellor or any such officer to monitor the observance of this interim protection order and submit a report to court in that regard. the accused or the perpetrator will be informed under Section 4, Subsection 3 that such an application has been made in court for a case of domestic violence. A protection order, once it is granted, if and when it is granted, can prohibit a perpetrator from entering any shared space with you. That could be a residence, a school, a workplace, or any kind of temporary accommodation. They can be stopped from contacting the victim or the victim's children. They can be stopped from following them around or stalking them. Court can prohibit violence against those who are assisting the victim, for example, a social worker or a family member. And also, a perpetrator can be prohibited from selling your matrimonial home or any such act that would eventually lead the victim to be destitute. Non-compliance with any such protection order could lead to a prison sentence of 1 year at maximum, or a fine not exceeding 10,000 rupees, or both. According to Section 21 of the 2005 Act, nothing stops a victim from bringing charges for other offences too, may they be civil or criminal, alongside a charge for domestic violence. And that is important to note as well. So it is necessary that we stay informed of the legal help that we can seek, not just for our sake or our protection, but also for the sake of anyone who would approach us for help in such a situation of abuse. So I hope that this outline of the laws and the situation would be helpful, and let's all take steps to stand against this menace that we call domestic violence, and that we will do for our sake and for society's sake. Thank you.